Sidebar, Bracewell's podcast devoted to government enforcement investigations, corporate compliance, and white-collar criminal defense. I'm Matthew Nielsen.
And I'm Seth DuCharme.
And we are your host and both partners at Bracewell LLP, where we represent companies, boards of directors, and individuals in all manners of litigation, investigation, and enforcement actions.
Well, hey, Matthew, it's great to be with you down here in sunny Miami for the annual ABA White Collar Conference. And this week, as in years past, the Justice Department has announced some, I don't want to say new policies, but perhaps some nuances to some of their existing policies with respect to how corporations are going to be treated. You know, I think it was yesterday, there were some folks talking about enforcement strategy and position from the department. So this year, like years past, has, I think, delivered on expectations and at least some messaging from the government, and then a promise, I think, with maybe even some more to come tomorrow. But it's great to be with you again, especially here in March in Miami.
Absolutely. I think this is the first time we've actually been in the same zip code and area for our podcast. So this is a fun one to do. So, well, I guess let's just kind of jump into it. The announcements, as you mentioned, are really focused on getting companies to come in and self-report early and to reward them financially for doing so, both from a reduced fine aspect, from a potentially avoiding monitorships, which can be obviously very disruptive and expensive. And so I know you've had some thoughts on this, but you have the main justice doing their policies. Interestingly, we saw some policies coming from your old stomping grounds, a couple of U.S. attorney offices kind of initiating a policy actually at the U.S. Attorney Office. Let me get your comments on that. I find that pretty interesting, right? Because, U.S. Attorney's offices ought to be following Department of Justice policies, right? And so I wonder, what did you see the need there for the U.S. Attorney's offices to kind of step out and kind of promote their own early self-disclosure policies?
Right. Well, there's always a little bit of a dance between the U.S. attorney's offices, out in the field all around the United States and the main justice components, which frequently have overlapping or complementary equities in what those offices are doing. And, depending on your perspective, sometimes the independence of the U.S. attorney's offices, so to speak, are celebrated and sometimes maligned, depending on how those offices are operating.
Right.
And I think to be empathetic to the corporations and counsel that have to deal with the department in one form or another, initially there can be a concern about, well, who am I really dealing with? Am I dealing with an assistant United States attorney from my local U.S. attorney's office today? But then will I be dealing with a trial attorney from a main justice component tomorrow? And is there going to be consistency in messaging? And it's not just the local U.S. attorney's offices in the region where the corporation or the individual's interests, may be implicated by an investigation. Many of these U.S. attorneys' offices, my old office, certainly, hunt way outside their backyard. So you may find, though you live in Texas, as you do, that you are dealing with an assistant United States attorney from New York.
Right.
And that can create, I think, some anxiousness on the part of clients and counsel about why am I dealing with them? And then when the main justice component comes in, it's, am I going to get different treatment or a different message from main justice? And the U.S. attorneys have a tremendous amount of authority and discretion. While there's these components in the Justice Department well below the Deputy Attorney General level, the U.S. attorneys essentially report to the Deputy Attorney General. Right. So unless you have some measure of coordination between the fraud section, let's say, and the U.S. Attorney's Office, you really do risk some inconsistency in messaging, some concerns about who to approach. Let's say you want to make one of these voluntary self-disclosures, who you're going to call. Are you going to call the local prosecutor's office that and have a historical relationship with? Or are you really going to have to satisfy someone else? And I think there's always a balance there to giving the U.S. attorney's offices enough discretion and independence to act in a way that's consistent with their institutional norms, their regional expectations, their bench, their community, and also report to the Justice Department, who ultimately, they all serve. So I saw the fact that the two New York offices came out essentially as representatives of the U.S. attorney community on the Attorney General's advisory committee and said, we're getting more linked up in the way that we think about these issues consistently across the U.S. attorney community and in a way that's complementary or harmonious, ideally, with how the main justice components are thinking about it. But at the same time, always leaving some room for the exercise of discretion within the offices, within the component.
Yeah.
So it's not cookie cutter, but I think it's a step towards greater transparency and consistency between the components and the stakeholders.
Yeah, you're right. It's trying to level set consistency across the country. Now, the question is going to be, and I laugh when you said it, is there's always a component of discretion and judgment, right? And I get that. You have to have that because I guess there's really no way to say it. But I think that's where the danger lies, right? You're dealing, and that's the case with, right. I guess, anything, all of this. But do they think you got to them soon enough to self-disclose? Because not only is there a element of self-disclosing before there's an investigation by DOJ or the U.S. Attorney's Office or FBI, but there's an element of doing it before an imminent threat that they were going to be told of this. Right. And so I don't know what that means, right? If you're, so many of these issues rise, and we can talk a little bit about compliance programs, but if you have an effective compliance program, hopefully you're getting these issues through internal reports, whether that is someone hopefully just feeling like the culture supports reporting it up the ranks, or you perhaps get a whistleblower anonymous report on whatever system that you may have. And there, sometimes whistleblowers, for instance, or sometimes employees don't understand that the time it takes for lawyers to come in and do the initial steps of an investigation to triage to see if there's something to report. And there's a concern of, am I racing that whistleblower to the government, right? Because certainly, there are incentive programs out there for whistleblowers. For instance, most notable, I think, is the SEC's whistleblower. There's a bounty program where they can get fairly substantial rewards for turning companies in. So there's always that judgment. It seems to me, and I don't know if you have a different view of this, that the department's been pushing this. I think we wrote an article together and then we spoke about kind of similar announcements last year at the conference by the Deputy Attorney General. And I don't know if we've had the time, or if it's an effort of time, or if it's a consequence of just the policy not quite working yet. But I think there's a lot of hesitation out in the defense community of there's a wait and see approach. And I don't know if I want to be the first one to test this new policy to see if I'm really going to get a better result out of this. What are your thoughts on that? What are you saying?
Yeah, I mean, look, there's got to be a mutual understanding of expectations, both with the corporation, the outside counsel, and the department. And that's always where the churn comes from. The department is essentially saying, look, we've got a carrot, we've got a stick. We're going to start from the point where we want corporations to act like good corporate citizens and to invest time, energy, money, and resources into compliance programs, to empower compliance departments to give real teeth to these things so that there is integrity and law-abiding behavior in the way our corporations conduct their business. And most corporations, I think, would say, of course, we are good corporate citizens. We conduct our business lawfully. We take compliance seriously. But on this notion of voluntary self-disclosure, there's certainly room for discretion. So on the one hand, I don't think the department or the corporations benefit if every in-house or outside counsel is calling some DOJ lawyer, whether assistant United States attorney, member of the fraud section, on a weekly basis, say, hey, I just want to check in. This is what happened this week. Are we good? Because that's going to turn the Justice Department into a Dropbox, essentially, of monitoring from afar what's probably in almost every instance going to be what the company would normally consider relatively routine internal issue that they can address as a personnel issue or as a business issue. And the department does not want to be overwhelmed with voluntary self-disclosures of things that are not crimes, right? Or regulatory violations for the other agencies. On the other hand, the huge risk that the corporations take if they don't report early enough is that they fail to meet expectations and the department says, what were you thinking? We couldn't have been clearer. Last year we told you we're taking corporate conduct really, really seriously,
right,
and there will be hell to pay, monitors imposed. Like, how could you have missed our message? And then we came back the next year and we said, report early and report often, and we're going to be consistent. So how could you think that it was okay to wait a year until you finished your internal investigation to wrap this all up? So there's a lot of room in between. There's still a lot of room for the exercise of discretion, I think, for corporations and their counsel and the department in how they treat the disclosure. But it's all, as you point out, what is the that's being voluntarily self-disclosed, and what risk do you really? It's fear of the unknown, right? Like, one of these whistleblowers.
Is it a suggestion of a problem, or is it?
Absolutely. And who's defining the narrative, right? So if we think, well, look, we think we have a handle on this. We don't think there's a there. Probably no need to call the government. But what if some third party or some disgruntled former employee gets overly excited and starts to define a narrative about the corporation in a way that's really interesting and exciting for the department? And look, let's be honest. They want to make corporate criminal cases. They've announced it. They've said, we want to do more of this. I think it was last year the DAG said, we're going to be bold, take chances. That's only a bit of a paraphrase. So they want to make these cases for general deterrence, specific deterrence. They want to swing that saber and show that they have policed the corporate community. So you can't, as a corporation, really drop your guard. You have to rely on a rule of reasonableness. And, I often wonder, we talk about, and I think all of us collectively, both in the department and outside, we talked about this objective notion of a rule of law, right? Like, we have a rule of law. We investigate crimes, not people. We investigate crimes, not corporations. You don't set out in an investigation to find evidence of a crime in a corporation just because your crosshairs happen to be focused on that corporation or that person. You've got to have a good faith basis to think there's a there. And if the objective application of the rule of law could be done as simply as we sometimes conceptualize it, there would be no mystery in this, and there would be no need for constantly revising policies and giving nuanced announcements, because everybody would know where the boundaries were. So it's interesting to me. I don't have the answer to this question, but I do observe that we have, I think, both in the government and as outside lawyers, we've got a lot of work to do to establish a common understanding of what the objective expectations are for compliance with the rule of law.
Yeah, I think that's exactly right. You and I have heard anecdotally, though, that these policies are, at least in perhaps in certain segments or certain areas of the country, are having kind of the opposite of, maybe not the opposite effect, but maybe an unintended effect of kind of creating this race to the U.S. Attorney's Office, right? And as you mentioned, instead of going to the office and saying, look, we've triaged this issue and we think there's something here, people are just kind of seemingly getting an internal report, and then outside counsel is just picking the phone up before they do anything else and calling the Department of Justice or U.S. Attorney's Office. And perhaps there's an overwhelming part of that aspect that's going on here. To me, I'd like to see the department give companies, and I think it'd ultimately be to the department's benefit, right? Give companies the time to triage. And I keep using that word, but I don't know a better one of, we're not talking about doing a fulsome investigation to kind of hand over, here's the crime that happened and here's all the evidence that supports that. That's not what we're talking about, because that can take a long time.
Right.
But at least having the ability to take any kind of internal report and kick the tires on it enough to know, does this have some potential credibility or not? And I think these policies are kind of having the effect of even discouraging that from happening, because you got to be first in the door to get these. I think that goes to the issue, though, of, and I do think the department has done a very good job. I'm not suggesting these other policies aren't a good start. I think they need to be revised, but I do think the Department of Justice has been doing a good job for the last few years of really focusing on compliance programs, and that they've gotten very smart about understanding what a real compliance program looks like and what it should be, and some very helpful proactive guidance we've talked about out there. Because ultimately, I think we all agree that companies cannot know, inherently everything that's going on, right? They rely on people to find problems. And in my experience, most of the time, those problems are discovered not from some kind of internal audit or some kind of legal review. They're found through informal sources, right? Some employee sees something, hears something, and hopefully reports up the chain, or you're doing a training somewhere and something that's said during that training resonates with an employee, and they say,
right.
well, hold on a second, that thing you were talking about, we may be doing that. And that's the key to this, right? And I think that's really what the department's trying to underscore here is, look, so that you can get this cooperation credit to be in the situation to do it, you've got to have an effective compliance program so that you can learn about potential misconduct internally before we learn about it externally, right?
Right. And like so many things, it depends on people.
Just emphasizing that.
Yeah. Like so many things, it depends on people knowing what their area of responsibility is, being able to communicate in both a disciplined way, but also a candid way, right? And the discipline in communication and creating the environments within the company where people can speak freely so that they truly do understand what their responsibilities are, I think is challenging, right? Human nature and all law enforcement to some degree is about managing human behavior, incentives and consequences for things, right? And there's a little bit of suspicion on both sides, right? Clearly, the government is a little suspicious about how seriously at least some corporations are taking their compliance obligations. And some corporations are a little suspicious about, well, what's going to happen, if I do report, does that mean I'm going to get a grand jury subpoena as a thank you, for what I've done? Is it just going to excite and incentivize the government to investigate me when there may not be a sufficient, from my point of view, basis to think that a crime has really been committed? And so much of what we've seen historically, I think when the rubber meets the road, when you actually start to look at the facts in these cases where there's smoke, let's say, but no fire, it's because of the way people communicated or miscommunicated within a company, or it's because someone like a compliance officer was given responsibility, but not real power. And right. That's a curse nobody wants. So you've got to, you got to find a way internally with the corporation to message to everybody from, top down through the whole corporation and to the edges. We take it seriously. It's part of who we are to comply with the law, to conduct ourselves with integrity. You should not be afraid to talk about things that concern you because we need to know, and we're encouraging you to come forward. And by the way, there are serious consequences for not complying with our own policies, including termination or compensation or possibly referral to the Justice Department for criminal investigation. So it's a challenging thing to do. And I think it can be done. I think there are corporations that do it well, certainly. I think, as you pointed out during this conference, unfortunately, some of the corporations that do it the best are corporations that have suffered consequences previously for not having done it as well as they maybe could have. So if you've got good communication internally, people know what their areas of responsibility are, what the expectations of the United States government are, and then you can deliver either comfort or concern to the government and say, we're on it. This is not who we are. This is an aberrant thing. Our system works. We found it. And this is what we think it means. And you can do that with confidence at the outset. Right. Then I think everything theoretically, at least, should work okay. The problem is if the expectations anywhere internally or with the government get crossed, and then, we as outside counsel, it's the worst possible position to be in, because our whole job is expectation management, right? You want to tell the corporation what's going to happen if we disclose. You want to tell the government what's going to happen if we do an internal. And if we're wrong, it makes things much more painful for everybody else. So, these are things you and I have talked about at length. I note, though, that at the conference this week, these are the same themes that keep coming up to the top of the conversation.
Yes.
On the corporation side, how do we know we've done enough? And on the government side, how could they possibly think they could wait so long?
Yeah, it is kind of this now recurring theme. And honestly, I think part of the problem is that this is kind of a spillover from kind of that early to mid 2000s era when, especially because when FCPA enforcement, for instance, was at its peak. And honestly, companies just didn't, at the end of the day, see the benefit in having self-reported those issues, right? And the government is trying to do its best to send a new message. And it's been doing it. This isn't new. It's been doing it for the last 6 or 7 years now. I don't think that attitudes within the actual lawyers within the government changed as quickly. And so I think there was a lag there. But I think we're seeing the government still trying to address those issues of those horror stories of spending potentially hundreds of millions of dollars doing an investigation and then, kind of walking away from a financial standpoint with significant fines and disgorgement. And so, like I said, it left a lot of companies thinking, well, why did we just go through that? Right. And actually even, many times questionable as to whether that company could have been convicted of a potential crime. There may have been wrongdoing, but, did it actually violate the FCPA or not? So I do think that there's going to have to be a change of perception, and it's going to have to continue, and we'll see, right? It's hard to keep message in government because it's driven by administrations. Administrations change, therefore the people that are running the Department of Justice and the U.S. Attorney's Office necessarily change because they're political appointees, as you all know. And so, but I do think at the end of the day, all of this is underlying kind of that message of good compliance is good business. To your point, where I think I've seen over the years, the biggest issues are one, kind of just a cultural issue where the company just, we've talked about companies that had they just done this, they would not have imploded like they ended up resulting in. But my point to that is that those companies were never going to do compliance the right way anyway, because it wasn't that people running that company, usually, interestingly, founders, I find more problematic than anything. That's not within their DNA and their culture. The other one is when a company, and I think this is probably more common, is when a company it grows exponentially or or its business changes and they're just not keeping up, right? And it's a good faith effort, but compliance is it's a cost center, right? It is unlike in the legal department, right? Which can have actually plaintiffs' cases that bring in money. Compliance never brings in money.
Sure.
It is just a cost center from a tick and tack. You can argue that it does bring in business. It's just hard to reconcile those two. But that's where you'll see the issues a lot of times is when you just really, your risk profile has completely changed and your compliance program hasn't kept up with that. And so, maybe a good time. I think we're going to have a conversation about this in New York in April. Do you want to talk a little bit about our roundtable?
Yeah, no, very timely, Matthew. I mean, we have scheduled for April 18th in New York. We're going to have a guest from the Justice Department who we've had some ongoing conversations with on these very issues, and they're really starting to crystallize this month in particular. What are the government's expectations of a, quote, robust compliance department? And, you said the compliance department can't make him any money, but it can certainly save you a lot of money down the road. That's right. On April 18th in New York, we'll have a guest from DOJ, and we're going to be specifically talking to our guest about the government's expectations and how the government thinks about evaluating compliance programs. Because if you can make the investment on the front end, and then, as you point out, scale that compliance investment and footprint as the company grows and its risk proportionally grows, then you should sleep well at night, right? Like if you listen to the government about what they want, you look internally, you do your risk assessment, and you grow proportionally your compliance department as your company grows, then you're going to be okay. That should be the takeaway from all of this. And I think it continues to frustrate a lot of folks, both here at the conference and around the country, about why it's so hard sometimes to know you got it right. So you can spend most of your time in the company doing, what you set out to do, which is making money, creating value for your customers and shareholders and working with your counterparties, and just know that you're doing it right. So yes, April 18th in New York, we'll have our roundtable, and our listeners can look for more information about that as the date gets closer.
That'll be a good discussion. Well, I guess we will continue to see how this evolves. Of course, the department is going to be looking to tout cases in which they've applied this policy. And so we've seen a little bit of that occurring. And my sense of it is that we'll probably see more, right? Because it just takes time for these cases to work their way through the system. And we'll be, updating. But it is an interesting time and interesting paradigm shift that's kind of happening. It's kind of like, it seems like it's kind of turning the Titanic, but it's getting there. And it looks like there's a good faith effort to really understand that and incentivize companies to do the right thing, self-report, and then to incentivize them from a financial standpoint of making it worth the while to do that. So,
right.
but more to come.
Yeah. And look, we shouldn't be too disheartened by the whipsaw of administration changes, which is inevitable. I mean, you and I have lived through a number of them now. It is true when new administrations come in, they set new priorities and they move resources around. But the laws that are being enforced rarely change. Sometimes they do,
right.
Be a new statute here and there over time. But for the most part, the laws that are being enforced are consistent. So if companies stay rooted in the laws with which they must comply to do their business, then the whipsaw effect will be a little bit less dramatic on what that company actually has to do. Every corporation, every individual should have confidence that if they're generally aware of the law, generally aware of the expectations of regulators and enforcers, they do their work in good faith, they're going to be okay. And the churn that comes from the pendulum swing, that can be mitigated, I think, by the stability that can come from knowing your own, know your customers, know yourself, know the law, and you'll survive those exciting sometimes changes in policy direction or resource allocation. Because if the law doesn't change, comply with the law, you're going to be okay.
Yeah, that's well said. Well, thank you for joining us for this episode of Sidebar. You can get this episode and others off of the Bracewell website and anywhere where you get your podcast.